Okay, we're going to start things off. Welcome to everyone who has been able to join us today. My name is Kiersten Amos. I'm a lawyer practicing labor, employment, and pension law here in our Halifax office of McInnes Cooper. I'm joined today by my colleague, Ryan McCarville, who is a lawyer practicing labor and employment in our Charlottetown office. And if you're joining us today, you are here for the exciting topic of employee monitoring and surveillance. Hoping you enjoy and take some nuggets of wisdom away from this presentation. Near the end of it, we will have a questions section. So if you do have questions along the way, feel free to pop them to us, and we will try to make sure we get as many answered as we can. So we're gonna get started. Make sure I'm on the right screen here. So as a quick note, what we are talking about today in referring to employee monitoring and surveillance is all the different ways, not in detail about them, but all the different ways that employers may or may not be considering or be actually engaging in monitoring of employees in the workplace, or monitoring of the workplace, which captures employee information, and surveillance, all of which is done in the overt or the open context. What we won't actually be covering today is circumstances where an employer may or may not choose to do subversive surveillance of employees for other reasons. So just wanted to be clear on that. And we will talk about a variety of different things, including software overlaying computers to track keystrokes and the legalities of that, video, audio recording, which is, I think, what a lot of people think of mostly when we talk about monitoring and surveillance, and even touching on a little bit on GPS. But before we get started, we thought we'd kick off with a poll and see from our audience how many of you are engaged in activities that would be considered monitoring of your employees. So hopefully this is going to work out well, and you'll have a survey that's popped up on your screen. Feel free to click an answer. It is anonymous, and there's no right or wrong answer. It's more of a curiosity and sharing. So do we have the results yet? "32, 61 no." Okay, so 32 of you answered that you do monitor your employees, and 61 of you have answered no, you do not monitor employees. So that's a third do, 2/3 don't, and a few who haven't answered either way. So we'll move on from that. Be curious to see down the road. We'll have another poll around policies and so on. So let's jump into it. Okay, when we get into talking about employee monitoring and why employers may consider engaging in activities that would be considered employee monitoring or surveillance in the workplace, there's a variety of different reasons why that may be the course of action the employer chooses, most of which have some varying level of being permissible, even with a little bit of caution. There's other rationales why an employer may do that, and again, we're not going to be covering that today, but it's the off-duty conduct, the covert, and for investigation purposes are all reasons the employer may consider doing some sort of surveillance. But those are ones that I think in law we would say are more one-off stuff that you should get a little advice on before engaging in. Otherwise, what we're focusing on today are the different reasons, one of which is a huge one, is operational requirements. So there's a variety of activities an employer may engage in that actually could fall within the scope of employee monitoring that are done for operational requirements. So for example, if you have a workplace and there's biometrics used to clock in and clock out for a time clock, that technically can be considered employee monitoring. If you work with a workplace that has a fleet, GPS tracking of vehicles for diagnostics on your vehicles, lifespan of your equipment, routes taken and efficiency, all could still capture personal information of employees and fall within the scope of employee monitoring. Another big reason why employers would engage in, whether directly or indirectly, employee monitoring is to manage productivity. Sometimes that's purely performance related. We'll talk a little bit more about that further on in the presentation. Some of it is not necessarily specific to individual employee performance, but about key metrics and service requirements and service delivery, such as in the IT world, where there may be response times for outages and so on, and software may help indicate whether or not you as a business have provided that service to your customer and where you're not, or where you're having gaps, and will help you refine and increase the productivity of the company overall. Which has a related impact on also being able to assess and monitor productivity of employees. So other things the employer needs to keep in mind or would be considering is whether or not they are doing it to help ensure compliance with legal obligations of the employer, whether it's minimum standards, privacy legislation. Workplace safety would be a good one if there's certain requirements to provide a safe workplace and it's a safety sensitive workplace. There may be additional reasons to put monitoring in place that is related to managing those obligations, legal obligations of the employer, both as an employer and as a company. And then last, an employer may choose to engage in employee monitoring for purposes of having evidence. And again, that evidence may be specific to the employment relationship, or it may be specific to other requirements for filing for compliance based on the industry you may operate in. So that's generally the main areas of sort of rationale for why an employer might choose to go down a route of engaging in monitoring and surveillance that includes or captures, whether directly or indirectly, the monitoring of employees. One note to also point to here is that as we continue in the presentation, we're going to talk mostly from the perspective of legal obligations and employers in Atlantic Canada, but where relevant and timely, we will be touching on other jurisdictions as well. So I'm going to turn it over to my colleague Ryan now, who's going to jump in and talk about employee privacy, a hot topic, and a particularly hot topic when it comes to surveilling and monitoring employees. So over to you, Ryan.
Thanks, Kiersten. As Kiersten said, privacy is a huge factor into this. It definitely plays a big role in determining whether you can monitor your employees and to what extent, and what that monitoring and surveillance may look like. So the case law has certainly evolved in recent years, and it demonstrates that monitoring, whatever type of monitoring you're doing, oftentimes you're collecting employee personal information, which triggers privacy laws and which triggers an employee's right to privacy. What the case law also demonstrates is that where we're talking about an employee working from home, an employee has a right to privacy in their home, but they also have a right to privacy in their work computer and in their employer provided device or cell phone. So even if you as an employer are providing them with a laptop to do their job from home and a phone to do their job from home, an employee has a right to expect that you're not going in and snooping on them and spying on their texts to their significant others and looking at all their emails without sort of good reason for doing that and without providing them with notice that you intend on doing that. So an employee has a right to privacy in their work computer and their work phone, even if it's provided by the employer. But that expectation of privacy can be diminished by employer policies. And we'll talk about how the employer goes about doing that in the course of this presentation here today. If you could go to the next slide. So when we talk about monitoring, employee monitoring, it's really, and whether it's reasonable or not, it really comes down to a balancing of interests between, on the one hand, the employee's privacy rights and the right to not have their privacy invaded by the employer on the one hand, and on the other hand, the employer's management's rights to manage the workplace and make sure that work is getting done appropriately. And Canadian law does generally permit employee monitoring, but the monitoring has to be reasonable. And it has to be reasonable in light of two things. One is the purpose. Why are you doing it? If you're doing it for security reasons, safety reasons, to improve customer service, those are reasons that tend to weigh in favor of management's rights. So that scale is tipped towards management's ability to do it in that case. But if you're doing it because of concerns around productivity, you have concerns that an employee is not going to be productive working from home, that tends not to be a very good reason. And in those cases, the balance is probably going to tip towards the employee's privacy rights, unless you can have some sort of evidence that you have a problem with productivity of working from home. So without strong evidence, without some evidence to support you going in and looking at what an employee is doing and monitoring their activity on their work computer, or other more valid reasons like security, customer service, those types of things, it may be found to be an unreasonable invasion of privacy if you're simply doing it to ensure that your employees are being productive. So you do need to proceed with caution. We'll go to the next slide there, Kiersten. So this slide sort of demonstrates the areas of law that come into play when we're talking about employee surveillance. And I don't intend on going through each one of them in detail, but I do want to speak to a few of them. The first is employment standards. So it's the kind of the top right one there. If the reason you're monitoring your employees is because you want to ensure that you are being compliant with employment standards legislation, you want to make sure that you're tracking their hours because you have to do so under most, if not all, employment standards legislation in Canada, and you want to make sure that you're paying them overtime appropriately, then that balancing that I just talked about may weigh in favor of monitoring your employees. But what that monitoring looks like is also going to be a factor into that. But that comes into play certainly when you're talking about monitoring your employees. The other piece I'll talk about on the employment standards is, and I think Kiersten may have some comments on this later on, but is Ontario employment standards legislation. There were some recent changes to that, which now requires that employers with 25 or more employees in Ontario have a written electronic monitoring policy, which must indicate whether the employer is monitoring the employees, and if so, how they're monitoring the employees. So we've seen that employment standards legislation be changed in Ontario to specifically provide for that in Ontario, and we'll see if that changes, if the laws are going to change at some point in Atlantic Canada as well. The next area that is relevant for this topic is privacy laws, obviously. Now, in Atlantic Canada, there's no privacy legislation that applies to private employers for the collection and use of personal information. There's a federal law, and then there's also some laws in some other jurisdictions, not in Atlantic Canada, that does apply to that. But some provinces also have privacy acts which provide for a legal action against the employer or another party for the inappropriate invasion of their privacy. So in Newfoundland, for example, they have the Privacy Act, and that act may come into play when we're talking about employee monitoring. The criminal code also applies, and that would apply in the specific circumstance of intercepting telecommunications without notice, so tapping into phones, that sort of thing, that would come into play there. But the big one is really the common law and contract law. And when we're talking about the common law or case law, as I said at the start, that has really evolved in recent years. Judges have now recognized how important privacy interests are to individuals. And there's been a new legal action recognized called intrusion upon seclusion, which is essentially snooping on someone else's privacy or private information. And where that snooping is inappropriate, the individual who's been the victim of that, even if they haven't suffered any damages as a result of that snooping, may have a right to legal action against the party who has done that privacy breach. So that new tort or legal action requires two things. One is the intentional or reckless intrusion into the private affairs of others. And the second is that the invasion is highly offensive. And if an individual can prove those two things, they may have a claim against their employer or whoever else has invaded their privacy. And then just on the contract law piece, that of course in the employment context, we're talking about the employment agreement or the collective agreement if you're in a unionized workforce, or employment policies. And as I said at the start, those employment policies can diminish someone's reasonable expectation of privacy in their personal information or in their work computer or phone. But the invasion has to be reasonable, and we'll talk more about that as we go through the presentation here. So the employer risks, and the risks is really twofold. One is the risk of the privacy breach itself. So if you as an employer has inappropriately breached someone's privacy, if you're in the unionized context, you face a grievance, you could face a civil lawsuit for intrusion upon seclusion, a constructive dismissal claim for breaching the implied duty of good faith and fair dealing, a privacy complaint as well under the specific privacy legislation, depending on what governs your workplace. And then of course there's adverse, or there may be adverse impact on employee morale if they believe that you're spying on them inappropriately. There's that lack of trust there. So there's risks associated with the privacy breach itself, but there's also risks in relying on the information that you obtain through monitoring and through an employee privacy breach. So let's say you monitor an employee's activity, that monitoring was inappropriate or a breach of their privacy, and then you go to terminate the employee based on that information. That evidence that you have may not be admissible in a court of law or at an arbitration or in front of another adjudicator. And so not only have you breached the privacy of the individual, but the evidence that you've relied on, you can't rely on legally. So you've now, that what you had cause to terminate an employee now becomes a wrongful dismissal claim against you because you can't use that evidence anymore. So it is important to not only make sure that you're monitoring your employees appropriately and that you're not breaching their privacy, but that once you gather the information, make sure that it is reliable and make sure that the evidence that you've gathered helps to prove your case and that it will be admissible in the future if needed. So with that, I will turn it back over to Kiersten.
Okay. So now we're going to talk a little bit more about where the law kind of lands on different types of monitoring and surveillance methods that may or may not be deployed directly or indirectly in the workplace. I'm going to start with work email, but maybe before I get in there, I'm going to start with the general lawyer's disclaimer for any of you who've seen me present before or heard me speak. I will always tell you that the classic lawyer's answer to just about any question you'll ask them is, it depends, and that's the best answer to give. because in the law likes to look at general rules and then apply them to specific factual circumstances. And you can generally argue in a number of different ways. If you change a few nuances or a few facts in a scenario, you may be able to argue it in a completely different way. So I start this section of the presentation with that standard disclaimer that while we're going to go down a road and talk about what is generally permissible without any worries, what is generally permissible with some caution, I will also note that generalization is subject to the it depends, and it may be more permissible or less permissible depending on how facts change. So digging into that, the first and easiest one to talk about, because most workplaces have email, not all, but most, is surveillance of employee emails. To the extent emails are being sent from an employer issued email address through employer networks on an employer system, all of those factors in that scenario start to mitigate against the employee having any reasonable expectation of privacy around those emails or the emails the employee chooses to send. So if, for example, you have employees who regularly email about personal matters on their work email, they do not necessarily have the ability to claim any privacy rights or entitlements around those personal emails if they've done so using almost entirely or if not entirely the employer's systems and emails. The flip of that is if the employer has not necessarily provided a work-specific email, has an internal system that allows employees to punt the internal messages out to their own personal emails, they start to use their personal emails to answer certain other things, which may or may not be work-related. The simple fact that they are using the employer's messaging system to punt messages out to their personal email will not extend a right to try and surveil or manage or view what else is contained in their personal emails. So generally speaking, as a general rule of thumb, because most of the scenarios fall into the first one I was talking about, the fact that it is employer driven would mean that generally an employer can engage in monitoring, can review, can have access to, whether actively and routinely or whether retroactively when an incident comes up and you're managing it, would have a right to look at employee emails without a big concern or risk that they are violating employee privacy rights. You can further, as an employer, mitigate against any of that risk by doing the standard policies to speak to the appropriate use of employer emails, the fact that emails may be reviewed and viewed and or monitored, and so on. So generally, it's a pretty easy and accessible way to monitor employees with very little risk. Second, which is still generally permissible, is monitoring employees' use of employer internet services. So we're talking here about online surveillance. It would be, or it covers the areas where employers will have appropriate use of internet, what is inappropriate use, and may run various different audits to ensure that employees aren't clicking on malware, accessing inappropriate websites, and so on. General rule of thumb is, provided that what you are in fact monitoring as an employer is your employer's or your company's internet accounts, then the employee in that scenario should have a very little expectation of privacy around what they do. Add to that the layers of, are they accessing it with their employer issued computer devices or phone devices? The more you layer in the employer around that, the less right they have to any privacy around their actions. The same applies though, the more you remove all of those things from the equation, the more they may gain some some right to privacy. It would never be absolute, but for example, if they brought in a personal device, hooked it up to the employer's guest Wi-Fi, and then perhaps navigated to some inappropriate devices, and you were able to track that all back to the employee, they may or may not have a slightly greater expectation of privacy. I still don't think that it would be a big barrier, but using that for comparison purposes. Again, managing that, the typical pathways and what most employers and companies have is standard HR and IT policies about appropriate use of internet resources and then appropriate conduct when using it.
If I could just add, Kiersten,
Yeah.
just back to your first point, it really does depend on the purpose and the way you carry out the monitoring. If you're going in to see if Joe has spent a lot of time on his hockey pool and you want to make sure he's being productive, that's very different than going in and making sure that there's been no malware installed on the computer and making sure that the websites aren't going to have a virus on the computer. So it really does depend on the circumstances. That's not to say you can't do it if you're just trying to monitor productivity, but it's not as strong of evidence as to the purpose behind your rationale.
That's a good point, Ryan. It's really what the expectation is around that. Another good example is whether or not you're doing it for passive monitoring or active monitoring is another way I would frame it up. Active monitoring meaning, are you going in and you're looking at it because there's a concern that you have, and this is an approach, it's data and information available to you as an employer, but you haven't otherwise been monitoring their online use, and now you're going in, like in the scenario with a hockey pool, to assess their productivity, is very different than if it is a passive where you're routinely monitoring, not necessarily specific for their access, but how long employees are on web pages, any web pages, irrespective of what those web pages are, versus when they're in the system software, because that is considered part of service to a client. Those are also two different scenarios on how we use online and can change the factual circumstances on whether this is an active investigation of an issue or whether or not it is part of a standard passive program that applies to all employees and happens to identify something and be available. The other thing that this is probably a good place to note is the difference when we talk about the case law in online surveillance, the difference being when an employer is conducting the online surveillance, whether it's active or passive, and let's use active as the best example here, where they're investigating something in the employment relationship and employment context versus an employer identifying something and engaging RCMP or local police to conduct a criminal investigation. One of the leading cases in this area is RV Cole, which is, getting older now. It's in the 2000s, but it's getting older now. But it was a scenario where there was an employee of a school board who was found to have inappropriate photos of underage student on their work issued laptop when they turned it into the IT department for some maintenance. It was and is a criminal case, and so it's very interesting to employers. Ultimately, there was findings around that particular employee's right to have a certain amount of privacy around what they had on that laptop that came through internet usage. But it's a different burden, and I speak about this often when I do sessions on employer investigations. How the law applies when the police are engaged and we're talking about a criminal investigation is a different standard. It's a burden of proof. So the burden around what you can and cannot do and the use you can make of that evidence on online surveillance when you get into really sticky situations, such as an employee with potentially pornography or child pornography on the computer, is going to be very different than what the standard applies to as an employer looking at a hockey pool, not just because of those being different facts, but about who's doing the investigation. Criminal standard is beyond a reasonable doubt, and that's because the consequences would have an impact on a person's life, liberty, and security of the person. In contrast, an employer can still do an investigation, doesn't have quite that onerous a burden. It's just more likely than not, or 50% plus one, to establish whether they believe what they found was inappropriate. So it's a different burden and not always comparable, and always good to point out. But when we talk online surveillance, those are kind of the key areas where we see the cases start to talk about it, and it's always important to note that distinction between a criminal application of the law versus civil. So move on from that one. Productivity software. So we're talking about different systems that you can install on computers that will track keystrokes, track whether the monitor is on, whether or not the VPN has been accessed or not accessed during certain work hours. Generally speaking, that type of activity is permissible, and employers can engage in that type of monitoring with lower amount of risk. Again, and without necessarily gaining any employee consent to do so. However, as always, de-risking that scenario is ensuring employees are aware that the reason for putting it in place is relevant to a business purpose, and mostly that you are kind of disclosing and you're not doing it subvertly. Makes it the easiest way to rely on any of that evidence. So then we flip over to overt video surveillance, and this is another good example of a type of surveillance where the factual circumstances or the it depends of it all really can change how you view the permissibility of conducting video surveillance. So generally speaking, it will be allowed, and generally speaking, it's allowed with certain notice, whether it's notice to members of the public or notice to the employees or notice to both. Most places you can conduct video surveillance. That is, again, not without limitations. A lot of the limitations do flow from what somebody would have a reasonable expectation of privacy around. For example, video surveillance in public communal areas of a workplace, in the lunchroom, out in the manufacturing floor, all permissible, but putting it into a change room or into a bathroom would not be permissible because the expectation of privacy is different in those two scenarios. Another good example of how things may change is whether or not it's passive or active, and I spoke to this just a few minutes ago, but you can have video surveillance in a workplace that is completely passive, in that you have cameras around and you have a system that records and then writes over it every 7 to 10 days, and nothing is ever downloaded and maintained unless there's an incident, and then if you have an incident, you access the video surveillance and you look at it. That's a different scenario than in a workplace where you may or may not have video cameras installed everywhere and actual staff members monitoring what they're seeing in real time in order to manage a situation. An example would be in a correctional facility, where you could potentially have staff who are deployed to actually monitor the video surveillance. Both of which are permissible, but both of which engage different privacy rights of the employees and the persons being surveilled, and the risks around that being best managed through having policies and providing very clear notice at the outset to employees and persons coming on the property that video surveillance is being conducted, and in the employment context, including it in, your employment agreements and your employee policies that people sign off on at the beginning, that not only gives notice but gains consent from the employees to acknowledge that they understand they work in a workplace where video surveillance is being conducted and they consent to be there. Another comment that, as I was preparing for this, one more example of where the facts would change things is in scenarios where we're seeing now coming out of the pandemic with more and more employers, losing their brick and mortar or downsizing their, their physical footprint and moving to remote or hybrid scenarios with employees, and requirements or opportunities to use not only keyboard but the webcams on your laptops and your computer devices to monitor employee activity, whether that's employee productivity in performing their job or also in security. You get into certain sectors or industries where confidential information may always be on a screen, and there may be a requirement to manage and ensure and control who all can see the screen, and opportunities to use devices such as the webcam to ensure that there's only one face or there's no cameras or phones trying to take pictures of what's on the screen. That's driven by cybersecurity or other security reasons. All of that will change. So all of those fact scenarios will lead into whether or not, if you're an employer with a remote workforce and you're considering, hey, I would like to monitor my employees by using and turning on or automating the turn on of their webcam so I can see when they're at their computer, and if their computer's in their own home, a larger swath of that would say that's probably not permissible, but it's not without exception, because there certainly would be industries and employers and scenarios where that may be entirely permissible. Again, mitigating that permission by giving notice to the employees, identifying the purpose, identifying why it's relevant, identifying whether or not there is anything less intrusive to accomplish what those relevant purposes are, and then deploying that type of surveillance would all help mitigate the risk around any privacy considerations with your employees. And then one other comment I wanted to make when I was preparing for this presentation, and I was reflecting on how, I've been practicing for 15 years almost. Videos have been out for longer than I've been practicing. And when I first started as a lawyer, video surveillance was essentially the big thing, and some people would be quite upset, and we were really talking more about videos in hallways of workplaces or in break rooms of workplaces, and reflecting on where technology has come since that day or over that period of time. But not only how technology has come a long way, the influence of that changes in technology is going to have an influence on how the law interprets whether something's permissible or not. It's now very clear that video cameras with a simple notice in a hallway in a building is permissible, because we are now developed as a society where we have very low expectation of privacy because cameras are everywhere. I think you'll see, as technology advances, the needs for security around everything cyber and how that influences the way different companies in different industries and different sectors have to operate will again further diminish our expectations of privacy around certain things that several years ago we would have thought we would have more privacy around. Completely unrelated to employee monitoring, my best example of what I'm trying to articulate there is vaccines. 10 years ago, the idea of requiring vaccines of employees was a big infringement on their privacy. We have a pandemic, we roll out vaccines, COVID vaccines, and require the general public to disclose that information. And the world shifted on that because it became such a lessening of that expectation of privacy with respect to that. I think coming back to use that as a comparison, the more we get into technology, the more I think you'll see those trends shift, that there'll be more and more, and some of it may appear more and more intrusive, but there'll be more and more reason why it needs to be that intrusive from a cybersecurity perspective. That will change how we can then expect privacy. So I don't know if there's any thoughts you might want to add on that, Ryan, but I feel like
No, I think it all comes down to the expectation of privacy. Does an employee have a reasonable expectation of privacy in their work computer, when they're walking down the hallway at the office? And then that's really going to depend on employer policies and the notice that's given to employees. So
yeah. And I think the other thing that I'm trying to articulate is I think it's not static in time. I think just because something was maybe outside of or offside of our expectations of privacy 5-10 years ago may no longer be offside because of a more pressing rationale that an employer or company may have of another interest they have to balance. So going back to that slide Ryan had of balancing the interests, it's always going to be contextual, so it's always going to depend. Okay, so another common method that we see is GPS. I know we've noted GPS in the company car, and again, I'll say this is where technology would say that GPS is no longer just in the company card. GPS can be in your ski can cards, whether it's GPS or something else. I know just going in and out of locks isn't necessarily, but in some workplaces it will track where you are in the building, it'll track where things are in the building. So another is the use of GPS technology. Generally speaking, it is permissible with consent of employees and with notice. Again, it has to be for a reasonable purpose. When we talk about GPS in company vehicles, it's often used for managing safety and development, promoting asset protection and management, which is what I was referring to on monitoring your fleet, the health of your fleet, whether equipment or physical assets are falling within or outside of their expected life cycle and needing replacement, and so on. And then also enhancing customer service. So response times, if you are in a business that does point of sale, services where you're out fixing debit cards and bank machines and the different things, timing of your response is equally important to the quality of your response, and GPS can be used to both deploy human capital assets and resources to fix those things quickly and efficiently, but also then to check the quality. So there's a lot of reasonable purposes an employer or a company would have for why they might engage in GPS type monitoring of employees. Again, the test of whether or not it's any risk is whether or not the use of it serves the purpose that you're trying to achieve and is not overreaching. Whenever it's maybe overreaching because yes, it's great, it's a gold standard, but not entirely necessary because we could have accomplished it by doing A and B and not necessarily C. In that scenario, you're going to get into a greater risk of having breached somebody's privacy rights. But absolutely, if A plus B plus C are reasonably necessary to fulfill that purpose, even though it may seem like an overreach into an employee's privacy rights, it would be permissible. And again, you're mitigating against the risk of it with good use of policies, good notice to employees, and consents, which can be achieved through the hiring process. And then biometrics, human recognition. So a very common one in a lot of 24/7 type operations where you're using time clocks now. A lot have evolved into using some sort of biometrics to clock in instead of the old punch card. A lot of good reasons for that. It makes sure it is the actual employee. So validating the employee that's clocking in is the employee who's clocking in. But also tends to feed into, and speaking to the reasonable purpose of it, then helps automate a lot of systems around payroll and time management. So generally speaking, where the law falls on the use of biometrics is that it is generally permissible, but again, this is one of the ones that's showing a bit more caution that because you really are in this scenario capturing what is going to be clearly personal information of the employee, and it has the ability to affect their personal interests. It is one where you will want to be cautious in mitigating those risks by ensuring you have the appropriate policies in place, the appropriate due diligence about giving notice to the employees. So when you're onboarding them, it's going to use your fingerprint, it's going to clock in, you have notice, you're now using it, you've signed your consents and so on. So that will be generally permissible. All right, that's the end of it for, before I turn it back over to Ryan, that's sort of the end of the section on the actual different means and where the law falls down. Hopefully you will have heard a very clear and a clear trend on where things are permissible but de-risk based on reasonableness, relevant, de-risk with policies and procedures and notice and consent. So I'm going to turn it over to Ryan to talk about some interesting cases on how some of this monitoring has been used and turned around and deliberated in the courts or arbitrators. So over to you, Ryan.
Thanks, Kiersten. And yeah, one of the reasons we chose this topic for this presentation is because work from home, as we all know, is very common now, and a lot of employers have concerns about productivity when an employee is working from home. Are they actually getting their job done, or are they playing with their kids, or slacking off and watching TV and that sort of thing? So,
Doing laundry.
Sorry?
Doing laundry.
Doing laundry, exactly. Yeah, well, I didn't say that because that's not something I tend to do, but in my household, unfortunately, but that's why that didn't come to mind. But yeah, there's a lot of concerns around that, and so a lot of the response has been, well, let's monitor the employees, and let's install software to monitor the employees, and that should not be your first reaction, and we'll talk about why that shouldn't be your first reaction here shortly. But before I get into that, I wanted to kind of talk about some cases on the topic where employers have installed that sort of monitoring type of software on the work computer. And the key thing is in those cases that there's a distinction between underperformance, so slacking off and being unproductive, versus time theft, where an employee essentially lies about what they've been doing, which is fraudulent and much more serious, and may give you certainly gives you a better case for cause for termination. So on the underperformance side, or the slacking off side of things, if you install software to monitor productivity and the evidence from that software shows that the employee has, yes, been slacking off, then you need to performance manage that. It is going to be very difficult to prove just cause to terminate an employee because they've been unproductive working from home. On the flip side, though, if you get an employee to submit weekly or monthly reports of things that they have been working on, and if they've lied in those reports, or they've submitted those reports fraudulently, and you have evidence of that, then you're going to have a much better case to terminate that employee's employment for just cause, because that's not slacking off anymore. It's slacking off plus it's fraudulent behavior, which gives you a better case for just cause. And there's a recent case out of BC just earlier this year. It was an accountant. She was employed for about 6 months with the company, and she worked from home. And a few months into her employment, she had a meeting with her manager because the manager implemented weekly meetings because of there was some productivity issues there. And shortly thereafter, the employer installed this time tracking software on her work computer with her knowledge. So she was aware that the time tracking software was installed. Then about a month later, they set up a meeting to discuss some files that she was over budget on and that she was behind schedule on. And the employer became concerned that, you said you worked 50 hours on this file. I'm not seeing that. So the employer went in and looked at that software. And the software evidenced that the employee had not, in fact, worked on that file at all. But she, in her report to the employer, said that she had worked 50 some odd hours on that file. So the employer has this evidence that, she says she worked on this file. Our evidence says that she didn't, but let's give her an opportunity to explain. They offered her that opportunity. They met with her. She couldn't explain. They then said, well, we realize this is taking you off guard, so come back to us with your explanation. We'll schedule a follow-up meeting. And she declined that follow-up meeting. So they ended up terminating her for just cause, and they were ultimately successful at the hearing. The adjudicator said, yes, there is just cause here. The employer was able to defend their position because not only was the employee being unproductive, but the employee had submitted false or fraudulent reports about what she had been working on. And so, and the employee was only employed for 6 months. So based on all of that, the employer had just cause to terminate their employment, the woman's employment. It would have been a very different case had that employee not submitted time cards or reports as to what she had been working on, because at that point it's just a slacking off situation where, you know, that's the same as if an employee had been in the office slacking off or talking a lot at the water cooler or taking long lunches. That's no different. That issue needs to be performance managed. So I just wanted to clarify that sort of distinction in the law on those two items. We'll go to the next slide there, unless there's anything you want to add on that, Kiersten. So we're going to get into now, kind of to wrap up the presentation, what are the best practices? Before we get into that, though, we have a poll on whether you monitor your employees, or if you do monitor your employees, do you have a written policy? And in my experience, it can either be a separate notice to your employees that you're going to be monitoring them, or it can be within an acceptable use agreement policy that says we're going to be monitoring you, and here's why, and here's how. So I'll get you to select an answer there. Okay, so those, not sure what the, so those that monitor the employees, about 55% do not have a written policy, and the other 45% do. As I said, oftentimes that sort of policy is within an acceptable use agreement, but sometimes it's kind of its own separate policy, or notice actually goes out, a separate notice goes out to the employees. So that's interesting. So I'll get you to flip to the next slide there, Kiersten. So the best practices. So first of all, set the stage to ensure good productivity in the first place, so that you don't have to monitor your employees or install time tracking software on their computer, because as we've seen throughout this presentation, that brings in privacy issues, and how you can rely on that information may be problematic down the road as well. So if you can resolve the productivity issues without resorting to installing time tracking software on the work computer, that's the best approach. Be clear about what the performance expectations are, what the employee's responsibilities are. If it makes sense in your workplace to have an employee submit weekly, bi-weekly, monthly reports as to what they've been working on, then that's a far better solution than having to resort to install software to address a productivity issue. Because as I said at the start, monitoring productivity is generally not the best reason to invade someone's privacy, and often the scales are going to tip in favor of the employee in those cases, unless you have evidence of a problem. Maintain regular communication with the staff. Certainly, virtual managing requires more structure than in the office, because you can't just pop by their office. So talk with your managers, your supervisors, about how do we make sure that people that work from home are going to be productive. Do we set targets? Do we set metrics? Do we have reports? Check-in meetings regularly? That all needs to be considered before resorting to employee monitoring. And then manage performance issues as they arise as well. Discipline employees, put them on performance improvement plans if you notice that there's performance issues, rather than taking that significant step of resorting to software installation on their computer. Let's go to the next slide there as well, Kiersten. So if you're contemplating installing that sort of software, assess the reasonableness and then establish reasonable grounds for doing so. What's your rationale for doing it, and how does that balance against privacy issues? If the rationale is client, consumer information, if it's security reasons, if it's health and safety, those are all very, very valid reasons. If it's productivity, then you should have some evidence of a productivity issue, and that evidence should support the need to monitor. What an arbitrator or a court's going to ask themselves if you face a problem after you install that productivity software on an employee's computer is, why is this monitoring necessary? What steps did you take as an employer to minimize the invasiveness of this? Have you contemplated other options than installing this software on an employee's computer? And if you have considered other options and for whatever reason those didn't work, then you're in a more defensible position by installing that sort of software on the computer. And as Kiersten will say here shortly, you got to give notice of that, and there's a process to follow there. But those are steps those are boxes you should be able to check off before resorting to that. Then the other piece too is, if you decide to install it, what information are you going to get back? Because sometimes the information isn't going to be that helpful. It's not necessarily going to show you a productivity issue. If it's active clicks, if it's time that the computer's open, those are sometimes not the best evidence in determining whether someone's productive or not. So even if you go to the extent of installing that software on a computer, is the information you're going to get back actually helpful to you? So those are things you need to turn your mind to before taking that step. So that's all I had on that slide. Kiersten, I'll turn it over to you. We're kind of towards the end of our time here.
Yeah, just to chime in on that last note, I think it is definitely a point not to lose, is losing sight of what, if anything, that evidence is going to give you that is actually what you're trying to measure, right? So, not getting lost in the idea of putting it on and then thinking it's going to allow you to tell how long they're at the computer, when there's ways to circumvent that, or there's reasons why somebody may be on their computer that's not. For example, if it only ever manages the VPN and somebody has a horrible internet connection and they go on and off VPN to get what they can, and then they work on a local drive, so being very mindful of what, if any, evidence it's also going to give you at the end of the day. Is it actually going to monitor for what you want to monitor for?
Exactly.
And then the last is just around implementation. Important as a best practice to disclose to employees. Again, we're talking here today about overt, obvious. We're not talking about subversive, type of operations that may or may not be warranted in different circumstances. So as a best practice, being upfront, disclosing to employees. If you have a unionized workplace, certainly your requirements around the policies and the implementation of that technology device are likely covered under KVP on requirements to give a certain amount of notice to employees in advance of any sort of negative consequence to their employment in the implementation process if you want it to stand. So disclosure to employees is critical for a number of reasons. Obtaining employees' written consent, which, as I was alluding to earlier, it doesn't always mean having a separate consent form for every single thing or a new consent form. It may be a simple blanket consent around acknowledging I work in a workplace where XYZ is done and here's the policies and I consent. Certainly can be an easy part of your onboarding process, but in other circumstances it may require a very specific consent, particularly if you're rolling out new software that's never been there before and is collecting information that didn't previously get collected. And then ensuring that, as you've hopefully learned, we keep recommending policies and managing through policies, but that the policy you do implement includes and spells out the expectations and what actually you're doing. So not only the reasonable purpose for doing this, but the collection, the use, the disclosure, how you're going to store it, and what security you're going to have around the employee's information as it relates to what you're implementing to monitor their activities. So those are all part of your best practices. And one last thing on the policy, which I know, Ryan, you spoke to, is just if we have any of our friends on the line are from Ontario, there is a requirement under minimum standards legislation to have an actual policy very specific to electronic monitoring that is separate and apart from the disconnecting from work, but that provides clear notice to employees, if you do, what methods you use and when and how it's used. Okay, so that brings us to our questions, or actually first, Ryan, over to you on the MC Legal Labs.
Sure, just before we get to our questions from the audience today, I just wanted to mention that McInnes Cooper does offer training on various topics for managers and supervisors. And if you visit our website, there's a legal lab section there, and that sets out all of our offerings. They're 90-minute sessions. We can do them virtually or in person, depending on the number of people involved. And if you think some training may be beneficial to your management group, certainly check out our website for those offerings, and or contact one of your contacts at McInnes Cooper or Kiersten and I, and we can give you some more details on those. So just wanted to mention that since this is a training session in itself. So with that, I guess we'll turn to the questions.
So we have a few received ahead of time, and there's one in the chat. So I don't know if you want to take first crack at it, Ryan, on the one in the chat. Sorry, my chat's on that screen.
Sure. So did you want me to answer the one in the chat or the ones we received up front?
Do the one in the chat. Let's turn it
Okay,
down.
so one in the chat says, at one time, case law would have indicated that the employer would have to expect a certain level or amount of personal use on a work-provided device. Has that changed over time as monitoring has evolved? I would say that, and I'd be interested in your thoughts on this, Kiersten, but I would say that no, I don't see an evolution in that in the case law since monitoring has evolved. I think that if the employer is providing the phone or the employee's laptop and the employee is allowed to use it for personal reasons, for banking or going occasionally on social media, for their own personal email, for whatever personal use, then there's an expectation that they're going to do that. And there's an expectation of privacy in when they do that sort of thing on their work computer. Now, as we said throughout the presentation, if your employment policy says that no personal use is allowed on the computer for whatever reason, or that they have no expectation of privacy in personal use on the computer, then that diminishes their expectation of privacy in that usage. But if it's an employer device, generally they're permitted to use it for personal reasons, but it really depends on when that use is and how much personal use they're engaging in. Are they doing it just on breaks? Are they doing it just after hours? Or are they doing it all day long? It's really no different than in the office setting as well.
And I would just chime in that use for personal purposes is different than having a certain levels of expectation of privacy around the personal use made of it. So if you have policies that speak to not allowing them any personal use, then to the extent they use it for personal purposes, they would have a lesser expectation of privacy around that, because it's been clearly told that they shouldn't set it separate and aside from whether they're violating company policy for using it. It would diminish their expectation of privacy, versus if you have an understanding and there is a certain amount of personal use allowed, which I think is probably the larger spectrum of employers. You know, the use itself doesn't necessarily equal expectations of privacy, but they may gain some. So I just kind of pointing to that they're separate but related issues. Question number 2 was, does passive video surveillance require written consent, or is a sign posted sufficient? For example, our recording system rewrites periodically. Recordings are not saved. It is in the place all the time to view the hallways, parking lots, and common areas. Access to footage is restricted, and it is viewed only if there is an issue. Yes, posted signs in that scenario where everything else is very obvious is generally the extent that you need to go. You may or may not want to overlay that with either a company policy or a human resources policy just to further document that. But generally speaking, the way consent would work in that scenario is if you've put a big sign up that says, "Smile, you're on camera," my proceeding into that area, knowing and seeing, you can imply that I've consented to be on video, and you have my consent in that sense. So it's an implied consent is how that operates.
Yeah, I agree completely. And I assume those videos are there for security reasons as well. And if that's the case, then absolutely there's no issue with that. Just going to some of the ones we received beforehand, we got a question on, can we check for active time on a work computer? And I think hopefully we've answered this through the presentation, but the answer is yes, it depends. Best practice is to give notice to the employees that you're looking at the active time and here's why you're doing it. And if it's for security reasons or customer service reasons, then that's a better reason than simply productivity. But best practice is to absolutely give notice and disclose it to the employees. But again, is that active time actually going to show you how productive they are, right? If they're on the phone with their colleagues or customers actually doing work, or if they print things off and read them, then checking their active time on a working computer is not going to give you good evidence as to whether they've been actually working or not. So while it may be permissible, how you rely on it's a separate question.
Yeah. And there's another question about what basic tenets on remote monitoring need to be in a remote work policy, and should it be a separate policy versus an IT security policy? My general advice on this one has been that it should be its own policy. You should have both, because they should be related, and they should point to each other, and they should be complementary and not conflicting. But generally, there's more that you may want to address in just the remote context of how you're accessing your devices and the security around it than a global company policy on IT security, which is probably dealing with both remote and brick and mortar and a few other things like audits. So that's my general advice. That yeah, it should be a separate policy. And then again, kind of what we've talked about, the contents of it itself should, speak to the purpose of the remote monitoring, the extent, why it's relevant, the acknowledgement that it collects, how the personal information will be used, how it will or will not be disclosed, and any security around it. So reverting back to our last slide. Okay, I think that's all the questions, and I know we've gone 8 minutes overtime, so thanks for everyone who has stayed on the line. Hopefully you've enjoyed it, and we look forward to seeing you on future webinars. If you have any questions, feel free to reach out to us. Always happy to answer offline. Thank you, everyone.
Thanks, everyone.